Welcome to the Probate Nation. My name is Richard Ruddy and I'm host of the program. People are living longer thanks to good health care and healthy lifestyles. But as we age, not everyone remains as sharp as they were earlier in their life. And frequently a loved one, a son or a daughter, is called upon as a court-appointed conservator to handle the finances of an elderly parent. As a court-appointed conservator, one of your core duties is to invest the funds you hold as a conservator. Sounds simple, but in reality this is a complex obligation. In the course of 2 shows, we will get into the details of your investment duty, what you can invest in, how you establish a financial plan and then an investment plan, and address a host of practical and common issues that all conservators face. With us tonight are 2 professionals who help conservators meet this duty to invest. Over the course of 2 shows, they will serve as our guide on what to do and not to do. Our first guest has worked as a financial advisor for over 25 years. He is a partner in Signature Estate and Investment Advisors, SEIA, a Tyson's Corner investment management and financial planning firm. He holds designations as a certified life underwriter, chartered financial analyst, and accredited investment fiduciary. In 2018, he created and SEIA launched the Life Care Affordability Plan, a financial plan and asset management solution designed to provide families with a financial strategy that meets changing healthcare needs while preserving the quality of the caregiver's life. Our second guest is a senior trust officer with Members Trust Company, a credit union-owned trust company that provides fiduciary-level investments and advice to their members. Before joining Members Trust Company, he served as senior litigation attorney at a boutique trust and estates law firm where he advised private clients on fiduciary administration and estate planning. He has an undergraduate degree in physics from UC Berkeley and received his law degree from Georgetown University Law Center. Please welcome Tom West from SEIA and David Carlson from Members Trust Company. Gentlemen, welcome.
Thank you.
We have a physicist.
Well, I wouldn't call me a physicist. I did get a degree in physics.
Okay, well, welcome, guys, and thank you very much for taking the time to share all your great information and kind of help us work through what is really a very complicated area. Mm-hmm. You know, when someone becomes a conservator, you know, that's one of the first things you're supposed to do is you got to go take care of, collect all the money and figure out, you know, what the needs are. But that actually is a fairly significant undertaking as you begin to gather stuff. It takes time, and so. You know, let's just start. Thomas, talk with you first. As a conservator, how do you acquire the authority to deal with the bank and brokerage accounts that you're now supposed to be in charge of?
The primary way that you get started is making sure that you're able to show the authorization that you've been given by the court to the appropriate financial institution. So the most important thing is to make sure that you are recognized as a conservator. The next most important step is to make sure that you change the title of these particular accounts in the name of the conservator. That's basically the best place to get started. But you have to show up typically with an identification to show that you are the person that the court, in fact, put in charge.
So, can this be done quickly? Typically?
Generally speaking, same business day. If you bring the information that you have, sometimes different financial institutions would require something like a medallion signature guarantee, but typically that can be done in the same business day.
So how does the money from the old account make its way into the new account when you go to the bank and you set this new account up? Mm-hmm. What do they do?
Well, generally speaking, you open up a new account which serves more or less as a bucket. And with the authorization that you work with the financial institutions, assets that are in the individual's account get transferred in kind without making any changes to them into the new conservator account that you, as the coin-appointed authority, are able to then make decisions on.
Okay. Now, we talked about bank accounts, but if I have a brokerage account, is that different? Does it can be done more quickly, or does it take a little bit longer time to do the same thing with the brokerage account that might hold a bunch of investment securities?
Typically, it's done the same way. The most important thing is to make sure that you're showing that you're appropriately authorized and that you get that title changed.
Okay. Now, I do know that in the case of the banks, they want you to physically come in and sign the signature cards. But in the case of the brokerage accounts, a lot of times they will work with you to send those things electronically so you can then sign them and then return them, as opposed to having to physically go into the brokerage house.
That sometimes is true. They're still going to want to make sure that identification is verified.
Sure.
But after that identification is identified, there are a lot of ways, or technology like DocuSign, you are able to do a lot of follow-up paperwork electronically for convenience sake.
Sure. Banks are a little bit more difficult. David, let's talk a little bit about how these bank and brokerage accounts should actually be titled, because I think the Commissioner of Accounts gets very upset about that when he sees these things showing up for an accounting, and they're not titled correctly. So let's get people started on the right direction.
Absolutely, and I think that's a great question because the banks don't know how to title it.
They don't.
So you as the conservator better know how to title it.
Sure.
And it needs to be titled very specifically, or the Commissioner of Accounts is going to he'll kick it back as an exception to the accounting. But it should be your name if it's David Carlson, conservator for the estate of, John Doe.
And incapacitated adult.
Incapacitated, right? Correct. One thing that happens regularly, strangely, but shouldn't happen, is that somehow these custodial accounts get titled jointly with someone else. That is a big no-no because that affects the legal rights of parties after the death of one of the parties.
So key is they cannot be titled jointly.
Correct.
Commissioner will have his head will start, or her head will
probably explode. Yes.
will start spinning about that. Is there anything that needs to be done with the title of any Fairfax County real estate if you are taking over and that incapacitated person owns a house, for instance?
So nothing has to be done with the real estate, and that's because the conservatorship proceeding is a public record. So it's all part of the Fairfax County. For example, if it was Fairfax County Circuit Court, we'll know that this real estate is now being managed by the conservator. If there's a mortgage and if there are utilities, then you do need to contact those, the lender and the utility companies to let them know that a new person will be the one handling these things.
That's true. Yeah, we do want to make sure we get that so they know how to send the mail directly to you now as opposed to the old address.
To the old address,
Sure.
absolutely.
Sure. Well, Tom, let's talk about this. We take over, we've got the accounts switched over. I now have bank accounts and brokerage accounts in my name as conservator. Do I have the duty as a conservator to invest these funds?
You do have the duty. And I think that sometimes is a misperception that there's now really a requirement upon you as the steward of these funds to invest, particularly. So I would call it a duty.
And is there a certain amount of time that I have in which to kind of get things moving and get these things invested?
Typically, a rule of thumb is about 4 months, particularly if you've got a portfolio that is not earning any income. That is the standard period of time that commissioners typically want to have the portfolio reoriented to whatever the current needs of the beneficiary.
Okay. Well, David, let's talk a little bit about, so are there Virginia statutes that actually address the investment obligations of a conservator?
So there are very specific statutes.
And
yes.
what are those statutes? Just kind of give me an introduction to those and we'll get into detail.
Great. So there are 2 sections that deal with that. And there are a list of legal investments in Chapter 15 of Section 64.2 or Title 64.2. And this goes through a list of specific investments possible, like bonds of the Commonwealth or of a city, that type of thing.
Okay.
There is another section under the Uniform Trust Code called the Prudent Investor Rule. And this is where it lays out, instead of specific investments, an overall standard and approach of investment that the custodian or the conservator is held to.
Now, we're talking about conservators, but do these investment rules, just because I want to alert our audience, do they apply to more than just the conservator?
Absolutely. And under the Virginia Code, it applies to every fiduciary you can think of. And so you could think of a trustee, you could think of an executor, you have your conservator, sometimes you have an administrator because there's no will. Sometimes you have an administrator with a will annexed.
People who have a power of attorney.
Power of attorney is a great example.
Those people a lot of times don't realize they have this obligation.
And they're one of the ones who frequently won't do anything. And then maybe mom or dad had put, gosh, I've seen it where they have $250,000 in one cash account at one bank, and then they got $250,000 in another bank because they want to make sure they're getting their insurance, right? And so you got all this cash sitting around not doing anything, especially with today's interest rates.
Sure.
So, but as an agent under power of attorney, you have the exact same duties. Yes.
So, Tom, let's talk about the legal investments. These are kind of like your really truly safe harbor investments.
Right,
Okay,
right.
Tell us a little bit. Do they authorize a list of sort of permissible or legal investments under that statute?
Right, and under that same statute, and we certainly give all conservators the guidance of actually looking up what are these safe harbors, and they typically involve bonds from the U.S. government, state bonds, deposit accounts that are FDIC insured at a lot of different banks. Mutual funds are allowed, and some investments like individual stocks that were in the portfolio from a legacy standpoint, sometimes those are permitted, but generally speaking, it's that list that we were talking about of real safe investments. It's also important for conservators to know that even inside of bonds, there's language in the statute itself to make sure that the bonds are investment grade and that they typically don't have maturities farther out than 5 years. Sometimes conservators are surprised that in the statute it's that specific, but that's a good resource.
Okay, that's important too. Well, let's switch to the other statute, which is the Prudent Investor Statute. So they've enacted this Uniform Prudent Investor Act, and this sets forth a standard for investing that's a little bit different, that goes beyond the sort of permissible stuff.
Right.
Tell us what that rule is, and
Sure.
tell us a little bit about that rule.
Sure. Well, the best way to describe the difference with the list we just talked about, think of those as essential ingredients to a recipe, but the prudent investor rule is sort of the recipe itself. How is a conservator obliged to put together these ingredients? And specifically the duty as it's spelled out in the statute is the duty to invest and manage the trust or conservatorship assets as a prudent investor would. And that breaks down into what is the purpose of the portfolio, what are the terms, what are the list of instructions that are actually in the document that the court put together, what are the distribution requirements, or are there any other circumstances of the trust that are unique? When we're serving conservators that might be coming at this for the first time, I always like to refer more colloquially as what's the job of the money? What is it supposed to be doing? And then you go through and you make sure that you're able to meet all of these different requirements, both in terms of purpose, terms, and distribution requirements, and making sure that your ingredient list is correct.
Okay. So the statute provides a default rule, David, but is there any language that we can put in our documents or that could be put in documents that we should be looking for that could change that default rule?
Absolutely. And you will see that change frequently in a trust or a will. If the executor, or if the testator or the grantor of the trust wanted to change it, they can waive by explicitly referring to the prudent investor rule,
okay,
or a prudent man. A general discretion to the trustee to do whatever they want is not enough. There does have to be a specific reference to this rule, or something like you can specifically hold X asset that may not fall into that category.
Okay. So, and the reason you would do that might be because we might have some of those legacy assets like Tom had mentioned that maybe we want to not be forced to have to liquidate an otherwise fairly illiquid investment because we're willing to hold it, maybe closely held business interests or something like that.
Yes, and that actually presents kind of a unique situation in the context of the conservatorship, because frequently you don't know what all those are when you're going in and asking the court to be appointed as a conservator.
Sure, of course not.
So just like the will has to say it or the trust has to say it, your conservatorship order must say it explicitly. It may be that your viewer has to go back to the court after they find out about some legacy position to ask to have that order amended to include that.
Okay. Okay. What is the standard of care, David, required of a conservator when making investments under this prudent investor rule?
So the standard of care is to, like Tom said, act as a prudent investor would act. That means you have to be reasonable and be prudent. I don't know that that's very helpful because that's pretty broad. But that is the type of standard that your actions will be weighed by the court if it's ever challenged.
And if I'm looking at this, looking backwards, do I look at and apply this rule on an asset-by-asset basis?
Absolutely, absolutely not. It is under modern portfolio theory.
Okay.
The courts look at it as an entire portfolio.
Okay.
So even if one investment that you hold went down in value, as long as that investment was part of an overall strategy that was reasonable and prudent, you will be okay.
Okay. So, Tom, let's turn to you. What are some of the considerations that may be relevant to a conservator in making investment decisions for an incapacitated beneficiary to whom she is responsible for? What are some of those things to consider?
Well, I think one of the things that David mentioned, which is a good place to start on that, is this concept of modern portfolio theory. It's a requirement of conservators to understand the risk associated with a particular position in the portfolio and how it impacts the overall way that the portfolio serves the beneficiary. But it's also a requirement that we look more broadly. We look at general economic conditions. We look at what's going on in the interest rate environment. We consider the tax consequences of a number of different decisions. Mostly what the guidance is going to be is you have to treat this very holistically, and you have to make sure that basically all the different pieces that you're putting together in the plan serve. Income and liquidity needs, we're going to talk about that a little bit in the next handful of minutes, are also going to be a consideration, but we always try to describe it with our conservators as it's your responsibility to know, when money needs to be made available, net of fees, net of taxes, with some predictability, and then how do you manage the overall portfolio to be able to do that with the highest likelihood of success.
Okay. And so what does the conservator have regarding investment assets once she has been appointed? What do they have to do? Once they've been appointed and they're qualified, so they need to review the assets to make decisions with you or an investment advisor and look at the range of options. You got a reasonable time to do so. They have 4 months and kind of to get going on that. Yeah. That's a short time period.
It is too, and I mean I think also if you consider that your scenario of having an incapacitated individual, I think that there needs to be due care to be able to anticipate how that care and the expenses associated with that care might change. And you're right, 4 months is a short period of time to try to put all of those different things together.
So we talked a little bit, David. So does a conservator have a duty to diversify? And I gather from our discussion he does.
Yes.
Do they have a duty of loyalty to the incapacitated beneficiary?
Absolutely.
So these are all important. What about investment costs? Are there any rules that govern what costs the conservator may incur?
And so it's a very generic standard of what is reasonable. So what is a reasonable cost taking into account the circumstances, how much money is in this conservatorship, and what are the skills of the conservator. So for example, if a member's trust company is appointed as the conservator, we can't then, in addition to paying ourselves a fee, go hire another financial advisor to manage the investments, because that's part of our expertise. So you have to use the skills that you come with, and then anything else that you want to hire an agent for, be reasonable in the fee that you're willing to accept.
Okay. Yeah. Now, David, in evaluating compliance with these rules, we kind of talked a little bit about that this is not really done in hindsight. It's basically we evaluate it on the circumstance that exists today. And if we meet, is that correct? Do I have that right?
That is correct, yes. And I think it's important to know that because no one can predict the future. Not even Tom and I, and we're the best at this, right? No, I'm just kidding. But we
can.
No one can predict the future. Maybe we think an investment portfolio is an appropriate strategy, and something goes down. As long as under the conditions that were in place at the time we made the decision, as long as that's all set, then we're not going to be held liable if an investment goes down. But likewise, if we get lucky and we gamble on some penny stocks and we get lucky and that stock goes up, the court's not going to absolve us of liability for not being prudent about our investment strategy.
And I think that's important for our conservators to understand. Okay,
yes.
Just because you happen to get lucky in that horse race that you happen to bet on, that doesn't get you out of the woods.
That's right.
Okay, so Tom, can a conservator I know the answers, but I want to make sure I've got this correct. Can a conservator delegate investment and management functions to an agent?
A conservator can delegate, but just because they delegate, it doesn't absolve them of the responsibility and the liability. It's still they are the ones named by the court individually. So imagine that you can have somebody subcontracted in to be able to supplement or augment the skills and the talents that you have. So it's pretty typical for outside advisors to be brought in, but that's something that doesn't absolve the conservator of their own responsibility to meet the requirements of these rules.
And how about the agent who's selected? Do they have any duty to the conservator?
They do have a duty to conservator. And one of the things that David and I were talking about in preparation for this is a discussion about the fiduciary standard itself. I think that it's important for conservators to consider, if they are going to be working with individual professionals that are helping them, that they themselves are required to meet a fiduciary standard themselves, and they don't have a lower standard that might not absolutely positively be serving both the conservator and ultimately the beneficiary in their best possible interest.
And would that standard be something that would be captured in the engagement?
It should be captured in the engagement. It should be in the registration materials that they've got. Typically, if you're meeting a fiduciary standard as a financial professional, then you've got documentation that is showing that that's how you're expected to be regulated by the SEC.
Okay, and that's important. I think that's, I know the securities people have, the agencies that regulate that have really cracked down on investment professionals over the last several years.
That's right.
Well, you know, this for a lot of our viewers is going to sound like a bunch of legal mumbo jumbo. Okay, so I think what I want to do is ask you guys to kind of translate that into some simple things that they can take away from the program. And so I'm going to ask you for your sort of final thoughts as you kind of pull together what we talked about in this part of the program. So David, I'll go to you first.
Okay, great. Yeah, thank you. So I think the first and most important thing to keep in mind is the duty of loyalty. When you are appointed by the court as a conservator, you owe an absolute duty of loyalty to the person you're taking care of. So you can't spend the money on yourself. You can't invest the money the way you want to. You can't invest it in your buddies. I'm sure it's a great company. You still can't do that, right? It's a duty of loyalty to look out of the best interests for your ward, for the estate of that ward. As long as you keep that view in mind, that gives you a good start. But it's not enough, because like we've discussed, you do have to know what modern portfolio theory says. And that's not a simple thing, but there are fee-based providers that are held to a fiduciary standard. They can provide you if you're a lay conservator without that background, there are fiduciary investment management companies available to provide you with that fiduciary level service.
And I think important to bring out to our viewers that those type of professionals who provide that service will frequently document that in some sort of a written document so that you can capture what you've talked about, what you've agreed to, so that way we don't have two ships passing in the night with some miscommunication. But that also becomes a way to protect yourself as the fiduciary, because you've engaged someone who's actually listened to you and then captured your agreement in a written document.
Absolutely.
So that's very important, I think.
And just one more thought to finish up there is, once you've hired the appropriate person, if that's the role that you take, check in every now and then. Don't just forget about it. You're the conservator. You've got to make sure that this company or agent that you've hired is still fulfilling their obligations.
We're going to come back to that, but I agree with you. I think that's the periodic review, and I don't mean every 5 years, I mean periodically during the year.
Right.
There needs to be some discussion, make sure the benchmarks are being met. Circumstances may have changed, so the needs you're funding may have changed. So we need to get back to that. Tom, tell me, it's your final thoughts, some things that come to your mind from our program discussion this evening.
Well, I think I want to compliment what David said about the duty of loyalty, that conservators also need to understand that there's a standard of care. Not only do you need to be meaning to do the right thing and holding to that, but there's a standard of care. There's a requirement that you can't wing it, that you can't be a complete amateur about it, that you have to pay attention. And it's also important to recognize that the standards that are in the statutes, they're not just for the beneficiary's protection, they're for the conservator's protection as well. These are really the instructions that the court in the state of Virginia are giving conservators to be able to make sure that that standard of care is met. And things like knowing modern portfolio theory, risk-adjusted return, paying attention to taxes, what's the broader economic environment, This is the standard that is required. And sometimes that's a lot, particularly if you've got a family member who's serving a conservator role but might also be a primary caregiver. There's certainly some bandwidth of what reasonable people can do. So I always want to remind people about the standard of care, remind them also that help is out there, and to not be afraid to ask for help if it's going to be too much of a challenge to do all this stuff themselves.
I think those are great comments, and I want to thank both of you guys for getting us started on this discussion. We're going to continue this discussion in another show, but so far I'm just overwhelmed with the information that we've passed on to our viewers. I hope I've woken up a few folks about things they need to do. But guys, thank you for taking the time to visit with us today.
Thank you, Richard.
You know, without a doubt, handling the finances for an aging adult can be challenging. And if you are the court-appointed conservator, there is a duty to invest the resources of that aging adult to meet his or her financial needs. As the show tonight illustrates, the rules governing a conservator's duty to invest are complex. Most conservators, regardless of their skill or experience, should get independent advice in meeting this investment duty. In part 2, when we discuss the analysis that needs to be done, along with the financial plan that needs to be created and implemented, and the common investment mistakes to avoid as a conservator, we'll pick that up. This brings us to the conclusion of part 1 of our show on Virginia conservatorship investments. We hope you found it helpful. Replays of this show and all the shows broadcast to date, along with other helpful information, can be viewed on the Probate Nation website. On behalf of the Probate Nation, thank you for visiting with us.